Hello, everybody. This is part three, and we're on to the TRIPS agreement, the agreement on trade-related aspects of intellectual property rights. Some of you may have studied intellectual property before, but for those who haven't, I think I still need to go through it in a reasonably comprehensive manner. And if for no other reason than intellectual property in many ways is a sort of strange fit in trade law. Trade law previously was always about goods. The addition of services in many ways seemed perfectly logical because the trade and services is such a large part of trade nowadays. I lost the video there. But intellectual property is rather different. So in what ways might it be said that intellectual property is tradable, is part of trade? And that gets to the heart of what is intellectual property. Well, intellectual property comprises a number of legal rights, those legal rights in relation to goods and services. Well, that seems quite a reasonable point, and might be sufficient for you to say that it does fit in trade law. Another way that intellectual property is relevant is the fact that these property rights themselves can be bought, sold, and licensed. And actually, license fees crossing national boundaries is actually a very important constituent of world trade. It's also quite closely related to investment as well. So a few things to think about as we get started. Let me just move on to the next page. Okay, intellectual property. I've said it. Intellectual property was not regulated under trade law previous to the World Trade Organization. It's not in GATT. It's not to say that it was never in any way relevant, because there were a small number of disputes about intellectual property during the GATT period. And interestingly enough, they all involved the United States. The United States was, in all four cases, the one who was the respondent to the country that being complained about. I'll say no more about this because obviously things have moved on quite a bit since then. Now, if you go back to 1986, the beginning of the Uruguay round, that's something I did mention before, but it is worth mentioning now, is that the Uruguay round was launched in a place called Punta del Este in Uruguay, hence the name Uruguay round, where the parties to GATT met to agree on the agenda for negotiations for the new trade round. And of course, it became known immediately as the Uruguay round, although the only negotiating meeting was in Uruguay was the one where they agreed on the agenda, and then meetings carried on in other places, including Geneva and Brussels and elsewhere in the years that followed. Now, there was a section of the declaration that launched the trade round and set out the agenda for negotiation, called Trade-Related Aspects of Intellectual Property Rights, including trade in counterfeit goods. And it's worth looking at this quite carefully. So you notice it says these are subjects for negotiations. So it says, in order to reduce the distortions and impediments to international trade. Distortions and impediments to international trade. Now, up to this point, most countries in the world did have a patent law they had a copyright law and they had a trademark law. But their laws were quite often divergent and rather different. Some countries provided broad and strong protection. Some countries provided much weaker protection. Let's take patents first. In many countries, patents did not allow medicines to be protected. There were also bans on the patenting of foods because these are essential items. Some countries provided quite strong public interest safeguards in their patent law, which were quite regularly used by the authorities. Some countries which had copyright law didn't allow software to be protected, for example, right? They didn't provide very strong enforcement measures. So either because the law didn't provide it or because there was a lack of will, a lack of interest in enforcing copyright. So, willful infringement on an industrial scale would have been quite common. Actually, it still is today in all the countries. Trademarks, counterfeit goods, counterfeiting of branded goods. Again, there was very limited enforcement in a lot of countries. Now, the United States was perhaps in the forefront of countries in the developed world that wanted to see other countries raise their standards of legal protection and actual enforcement to the same level as in the United States or in Europe or in Japan. So they had to make the argument that to raise global standards of protection, the argument that this was a trade issue. So in what way might you say that inadequate, or well, what is adequate, what is inadequate is an interesting issue, but what is having less protection in other countries, in what ways does that distort or impede trade? And it's not an obvious answer to this question. First, distortion. The idea here is that allowing international trade in counterfeit goods or pirated goods, like I should say the word piracy tends to be used in relation to copyright infringement or taking advantage of the unavailability of copyright. Whereas counterfeiting is usually in area of branded, trademarked goods. I'll just say it for now. In what way is that a distortion? Well, it was argued by the United States, their trade representative, that allowing a trade in fake or counterfeit pirated goods across national boundaries without any serious efforts to prevent it is a distortion of trade because it means that genuine goods, their trade is effective and they are competing with fake goods. And fake goods have the advantage because they're probably going to be cheaper. Impediments to trade, well, you might say, from the perspective of the United States, that it follows from this that an impediment to trade in genuine goods is a consequence of inability to enforce the cross-boundary traffic in fakes. And so again, that was used as a justification because distortion and impediment to trade are clearly sound like something that trade negotiations ought to cover. So, okay, so taking into account the need to promote effective and adequate protection of intellectual property rights. What is effective and adequate? Is that an objective assessment, or is that some rather subjective? I mean, adequate, how much is enough? is intellectual property is a very hard question to actually answer. Economists, some of the world's best economists, have applied their thinking to this and still don't really have a definitive answer. Okay, it goes on to ensure that measures and procedures to enforce intellectual property do not themselves become barriers to legitimate trade. Well, how can that happen? How can enforcement become a barrier to legitimate trade? Okay, well, one way that this could happen is that that patents, copyright, and trademarks do have their exceptions. They do have their limitations to rights. So in copyright, for example, you have in copyright in the United States, you have the fair use doctrine, provides quite a broad scope for using a protected work and being able to use fair use as a defense against being sued for infringement. And you have other measures in patent law and in trademarks. So it might be that overzealous protection could harm trade, which is perfectly legal and legitimate. Another way, and actually there was a country in Africa which did this, that in their attempts to prevent the trade in counterfeit goods, wrote the law in a way that actually would have prevented the perfectly legal trade in generic medicines. It would have interfered with that. So overprotection, overzealous enforcement can go too far. And it says the negotiations shall aim to clarify GATT provisions and elaborate, as appropriate, new rules and disciplines. And it says negotiations shall aim to develop a multilateral framework of principles, rules, and disciplines dealing with international trade in counterfeit goods, taking into account work already underway in GATT. A multilateral framework of principles, rules, and disciplines dealing with trade in counterfeit goods. Now, if you read that, you might think that, well, this sounds like it's pretty much just about trademarks, right? Because trademarks, or counterfeiting is normally used in the context of trademarks. So, and it's often argued that many of the developing countries agreed to have new norms on intellectual property because they thought it was mostly about counterfeiting. Well, who's in favor of counterfeiting, who says counterfeiting is okay. So there is this argument that developing countries had no idea what they're getting into here. And of course, TRIPS becomes a lot more comprehensive. More comprehensive, yes. So not just about trademarks, includes copyright and related rights, geographical indications, which then was a completely new concept in international law, industrial designs, patents, layout designs or topographies of integrated circuits, IP protection that is really of interest to only a small number of countries, in fact, because not many countries are involved in semiconductors, and the protection of undisclosed information. Now, I won't go through all of these. I will go through some of them, because that's all I really have time for. But first, some key parts of the agreement. Like most international agreements, there is a preamble which sets out the general reasons for the legal instrument. Why have it? What purpose is it meant to fulfill? And sets out some of the basic principles. General provisions and basic principles, again, which are, I mentioned the basic principles already, but these are given a little more legal weight, more legal clarity. And standards concerning availability, scope, and use. And those standards are the ones that obviously cover all those rights. Those are the standards in those areas of IP. And then enforcement. Okay, now It's sometimes said that much of the language of TRIPS reflects a compromise in the input of negotiators from the United States and the European community. But there are certain articles where developing countries had quite a big say. And Article 7, the objectives, reflects this idea there should be some kind of a balance. So on one hand, you have the protection and enforcement of IP rights. So we say these are good things, but this protection and enforcement should contribute to promotion of innovation and to the transfer and dissemination of technology, to the mutual advantage of producers and users of technological knowledge, and in a manner conducive to social and economic welfare, and to a balance of rights and obligation. I can't really stress the importance of Article 7 enough, really, because clearly the idea is we don't want overprotection, over-enforcement. We want to have a balance, right? A balance so that social and economic welfare are promoted. And there is this balance of rights and obligation. And it reflects the fact that developing countries lack industrial technologies, and intellectual property rights should not restrict or restrain this transfer and spread of new technologies around the world. In Article 8.1, principles members may, in formulating or amending their laws and regulations, adopt measures necessary to protect public health and nutrition, and to promote public interests in sectors of vital importance to their socioeconomic and technological development. So why is that there? Measures necessary to protect public health. Well, as we'll see, one of the key provisions is that of TRIPS is that in patent law, patents must be available in all fields of technology. Fields of technology is somewhat a vague term, but it does mean effectively in health, in medicine. So you must now allow patents to protect drugs. That's quite controversial for many countries. So this language, measures necessary to protect public health, is there in a way to set some sort of balance. So you have to allow medicine to be patentable, but at the same time, public health remains, if it remains a priority for your country, then there must be, again, some kind of a balance here. And promote the public interest, which is perhaps a reminder that intellectual property really is not, well, I don't want to be too sweeping about this, but intellectual property is largely something that is meant to benefit society as opposed to just inventors or just artists or writers. It's meant to benefit society as a whole. Okay, so intellectual property is nothing new, right? Patents and copyright and trademarks go back to the 19th century, in some countries even earlier, so there's nothing new. And WIPO, the World Intellectual Property Organization, which administers about 24 treaties on intellectual property, is the main international organization dedicated to promoting and IP around the world. And the fact that World Trade Organization now also deals with intellectual property is quite, obviously quite a recent development, going back to foundation of the WTO, not previously being in trade law, except saw in a tiny number of disputes, of GATT disputes. So what is actually new when you look at the language of TRIPS? In summary, there are 5 new things. So there are 5 novelties about TRIPS. One is the extension of patentable subject matter to medicines and inventions in biotechnology. Second is geographical indications. Now, there is a treaty, a WIPO treaty, WIPO treaty called the Lisbon Agreement, which is about appellations of origin, which is rather similar, but geographical indications as a broad concept is a very, very new thing, and very much a European thing that's become globalized. And the third is undisclosed information. Again, it is a kind of new thing. It's a new kind of intellectual property right. Is it intellectual property? It's somewhere between property and regulation. It includes trade secrets, you probably all know about, but it's not confined to trade secrets. There's much more to this, and we'll look at this a bit later. Fourth is enforcement requirements. Previous IP law treaties have very little to say about enforcement. In the case of TRIPS, members of the WTO are required to provide legal and other procedures to permit effective action against any act of infringement of IP rights. And then there's, of course, the availability of the dispute, the WTO dispute settlement system. There have been 38 disputes to date that are partly or wholly on TRIPS. Not a huge number. I would have expected more. When going back to 95, back in those days, I thought, well, surely there'd be loads, and 38 is not actually that high a number. All right, so copyright law. What does TRIPS have to say about copyright law? Now, I mentioned before this idea of incorporation by reference, where a legal agreement incorporates the text of other legal agreements by referring to them. And I said that in the context of GATT, and I said that the text of GATT 1947 is incorporated by reference into GATT 1994, even though the two are legally completely separate agreements. Actually, GATT 94 no longer exists, but the text lives on in GATT 94. Similarly, the TRIPS agreement incorporates by reference other treaties, other non-WTO treaties. And the Berne Convention for the Protection of Literary and Artistic Works, originally signed in 1886, its latest revision was 1971, is incorporated into the TRIPS agreement, all the substantial parts, except one part, which is Article 6 bis. Article 6 bis is about the moral rights of authors, the right of attribution, the right to be named the author of your work, and the right of integrity, the right not to have your work distorted or spoilt by somebody else in a way that would affect your honor or your reputation. Why? Because the United States, there's a very clear thing here, it's well known, the United States wanted to see Berne Convention incorporated into TRIPS, but the United States at the time did not provide moral rights for authors and artists. At the time, slightly changed since then, at the time, because the United States did not want the business model of the movie industry, and I guess also music, entertainment more generally, the business model of particularly Hollywood to be affected by giving actors and other people who contribute to movies, give these people moral rights that are separate from economic rights. It was seen it would make contracts, licensing much more complicated. So the United States did not want moral rights to be there. So it insisted that Article 6 bis of the Berne Convention be not required, that part of Berne. And then Article 9.2, copyright protection shall extend to expressions and not to ideas, procedures, methods of operation, or mathematical concepts as such. This is the idea-expression dichotomy, which was first delineated in US copyright law, but is now pretty much global. You cannot, copyright does not protect original ideas, no matter how original. It only protects expressions of those ideas. That's a fairly simple thing to understand in relation to literature, where you could have the same plot. Two authors could have the same plot, but their novels would still be different because they're expressed differently. Expression idea separation doesn't necessarily work particularly well with modern technologies, but that's another matter. And then Article 10 says, I'll just look at 10.1. It says computer programs, whether in source or object code, shall be protected as literary works under the Berne Convention. Now, the first country was the United States, the first country to state in their laws that software code is a literary work for the purposes of copyright law and therefore protectable was the United States. So now that is the global standard. So software is protected, software code as a work of literature. Okay. And then there are rental rights. I shan't say too much, but in a way, this is a kind of secondary right, which is quite a new thing in copyright law, reflecting the fact that copyright works are sometimes they are the purchaser of a work purchases on a purpose for the purpose of renting the work to others, and this raises some concerns with copyright owners who say, well, there's been one sale, but the consumption of the work is being increased by the fact that it's rented out, and others are making money by renting out this work to others. So rental right was incorporated into the TRIPS agreement to meet this particular concern. So when you look at the copyright part of TRIPS, you can see that it is very, very pro-industry. Does it have safeguards? We'll come to that in a moment. Does it have some public interest safeguards? How does it balance out with Articles 7 and 8 of TRIPS? Okay, I'll come back to that in a moment. But what about term of protection? The difficulty with copyright is that nowadays works are protected are not authorial works, or there is not an individual author who is identified. You may be aware that under Berne, the standard is, in the case of artistic and literary works where there is an author, the term protection is life of the author plus 50 years after his or her death. That has actually the standard, the length now tends to be longer than this, but that's under the Berne Convention. But of course, there are nowadays works where there is no author. I mean, a sound recording is there an author? Well, no, there isn't. It is an entrepreneurial work. It is a work that is owned by business. And so for different types of work where there is no natural person who is the author, you can't calculate from death, the death of the author, can you? So there are certain minimum periods of protection. You can see these are all quite long terms. If you compare to a patent, it's 20 years. A copyright is much longer. Okay, so safeguards or limitation exceptions to rights. TRIPS has a test, we call it the three-step test. The three-step test originates in the Berne Convention, right? which is very much related to, it is linked to the interests of authors. TRIPS slightly changes the emphasis of this, so it goes from the author to the right holder, which reflects a very American, or you could say an Anglo-American view of copyright, which emphasizes the economic interest of owners who are likely, or controllers of rights, who are likely to be business. Whereas the French or German, actually, it's also Spanish and continental view generally, is that copyright is really centered around the author, right? And so there would not be reference to legitimate interests of rights holders, but the legitimate interests of authors. So anyway, look, it's a three-step test. So where are the 3 steps here? Okay, let's go through it. Members shall confine limitations or exceptions to exclusive rights to certain special cases. So only for certain special cases, which do not conflict with the normal exploitation of the work. 2. And 3, do not unreasonably prejudice the legitimate interests of the right holder. So there's 3 steps there. It's one sentence, but 3 steps. So this is, so basically every country's copyright laws, to be compliant with TRIPS, every country's copyright laws where they provide exceptions or limitations to rights must be in accordance with these 3 steps. Certain special cases, these cases must not conflict with a normal exploitation of the work, and 3, must not unreasonably prejudice or harm the legitimate interests of the right holder. Right. This is actually very, very important, even though it's a little bit vague. It's a bit unclear what it actually means. Right. So I'm going to tell you about a particular dispute which actually involved the United States. I'll tell you some of the background to this. Okay, so a background to this. Right, now the United States passed a law, and the law made it legal for owners of certain services, such as restaurants, bars, and shops, to be able to play sound recordings, to play music, without having to get a license from the rights owners. Now, if you, perhaps in your own countries, I suspect in your own countries, and certainly in my own, if you own such a facility, if you own a restaurant, why do you play music? In your restaurant or in your bar, why do you play music? Well, you want to attract customers, you want to create a nice atmosphere, you want them to stay, have another drink, right? To stay in your place. So there are business reasons why you want to play music in your, and of course, as I say, probably in your own countries, it's quite standard, quite normal practice for these facilities to get a license from a collective management organization, a collective society. So the license, you pay, but then you are indemnified from infringement suits. But as I say, the owners of the sound recordings and hopefully the performers and the authors of the music will get some money. The United States went the other way and provided a very, very broad exemption. Back in the late 1990s, an organization of Irish musicians got in touch with an Irish lawyer and said, look, and of course quite a lot of Americans in Chicago, New York, Boston, do have Irish ancestry, and as you might expect, they not just sort of drinking Guinness, but they and celebrating St. Patrick's Day, but they also like to listen to Irish music. So the Irish musicians, through the lawyer, a man called Bernard O'Connor, went to Brussels and said to the European Commission, look, the United States is allowing this unlicensed playing of music, including Irish music, and this is surely not permitted under the TRIPS agreement. So the European Commission raised a complaint at the World Trade Organization, and this led to a panel being set up and producing a report, which was in the year 2000 was adopted by the General Council of the World Trade Organization. And the panel looked very carefully at the three-step test, right? And they found that broadly speaking, the United States Copyright Act, in permitting the unlicensed playing of music to fail every 3 steps of the test. It failed the test, and therefore under WTO law it was illegal. Now, the United States defense was to say that this does not interfere with the normal exploitation of the work. It is a special case because actually it is the cost of making all these businesses get a license, the cost of actually getting a license would be higher than any benefits that the rights owners would derive from complying. From complying with, no, because it did comply with the test, but by forcing them to license, it would be more expensive, and so therefore, the owners of the rights would not actually benefit. So it didn't interfere with their way of making money because of the transaction costs involved in making these establishments license their rights. The panel said, well, no, that's just not correct at all. However, the US defense only works in the case of very small places, small bars, where the owner brings in his or her domestic music playing machinery, a small CD player, the sort you have at home. In that case, it would be very difficult for the rights and expensive for them to force these places to license. And of course, these smaller places don't have many customers compared to, let's say, a large bar or a restaurant which has equipment to amplify music in a much larger room. So the home style exemption, as it was called, was actually legal. So home style exemption. So as long as the exception to rights was confined to these smaller places, then then the US law was compliant. But the broad exemption, no, it was not compliant. So the United States, since then, through arbitration, has a compensation scheme because the United States has not, in 20 years, changed its copyright law. It has not changed its law to become compliant. So instead, it has a compensation scheme for the European European rights owners. So There we go. So that at least explains what the three-step actually means legally. Okay, there's some details here, which I won't go into. You can read about this later. I'll make sure the slides are available to you, that you, as a separate document, you can look at those later. And, well, so it goes on rights of performers, use of photograms, etc. I'll move on to patent law. So, again, patent law in TRIPS incorporates, by reference, another long-established treaty, which is the Paris Convention for the Protection of Industrial Property, which was originally signed in 1883, 3 years before Berne. Its last revision was 1967. And this is the key provision here, Article 27.1. Patents shall be available for any inventions, whether products or processes, in all fields of technology, provided that they are new, involve an inventive step, and are capable of industrial application. New, inventive, capable of industrial application. Now, I should say that is the European standard, but as alternative terminology, in a footnote, it can involve an inventive step, can be, it is not obvious to a person skilled in the art, and capable of industrial application. That's a European sort of construction. We in the United States they'll say useful. So new, unobvious, and useful. But in terms of what they mean in actual practice, is US and in EU is not that, or Europe rather, is not that different. And I won't go into the minor differences here. Patents shall be available and patent rights enjoyable without discrimination as to the place of invention. So here you have non-discrimination again, which is of course a running theme in trade law. But in the sense of the place of invention. So if you invent something in Istanbul or Athens or London, or you do it in Chicago, it shouldn't matter in any way. Why does this matter? Why is this actually, why does this provision matter? Why is it important to say this? And the reason why, actually, and this was something the United States had to deal with, had to resolve, was that in the US, until recently, a patent disputes often centered on who was the first to invent. Who was the first to invent? That has actually changed since 2011 with the new legislation in the United States, the American Invents Act. Elsewhere in the world, the patents go to the first to file, the first to get to the patent office, not the first to invent. The first to file practice sounds perhaps a little bit unfair. Surely the first inventor should get the rights. And for a long time in the United States, that view was held by many people. On the other hand, the European, the rest of the world view of first to file, first to apply, in other words, is that this is actually more legally certain, which is also true. Because with first to invent, well, how do you know these researchers here, these researchers there, how do you know who was first? Well, you may have to go through a lot of laboratory notebooks to find out who was first. It can get very, very complicated. And at the time in the United States, up to that time in the United States, they only took into consideration this kind of evidence for inventions made in America. So if your invention, you might have your invention made in Athens or Istanbul or London. You may have all your in laboratory notebooks and say, look, we were the first, and here is the evidence. Judges in the United States were not required to even look at that. So there was very much a bias in favor of inventions done in America. So that had to be changed. Okay, the next clause, the field of technology. So there's no definition exactly of field of technology, but clearly the idea here is that although it was the intent of the United States that this language be adopted to ensure that countries didn't say, look, well, we're going to exclude software, we're going to exclude medicines, we're going to exclude foods. And the language says, well, no, you can't. Well, no, you can't. Actually, you can if you're European, if you're Europe, because we do say that computer programs as such are not patentable. It is in European Patent Convention, and the United States has never complained at the WTO about this. But sometimes it depends on who you are, whether you're able to interpret this language rather creatively, and whether products are imported or locally produced. So you may want to manufacture your invention in another country and then import it. And of course, that doesn't make any difference. But the real purpose of that last part of the language is that traditionally in patent law, a lot of countries have so-called working requirements. Now, what is a working requirement in patent law? Well, in the past, a lot of countries had in their laws that failure to make the invention in the country where the patent is owned can be grounds for revoking the patent or a compulsory license. And that was justified on the basis that granting a patent, particularly granting a patent to a foreigner, should not be a free gift. Your obligation should not only be to disclose the invention in the patent document, but you should also be required to manufacture the invention as well in that country. And that, in a way, transfers technology, and it also it employs local people. So there is an economic benefit for the country that grants the patent, even though the patent goes to a foreign inventor. That was, going back a long time, that was opposed by companies saying, well, why should we have to set up factories in every country where we have a patent? Why can't we just export? But in 1995, there were countries that still had local working requirements, and arguably some countries still do. United States actually does. Under certain circumstances, the United States does, and so does Brazil. And you find actually there's still working requirements in quite a lot of other countries as well. So they haven't gone away. They're just, let's say, weaker working requirements. In other words, the sanctions for failure to work is much less strict than they used to be in the past, but they haven't completely gone away. So here are the criteria, the requirements, which I've already sort of mentioned before. Well, I should also add enabling disclosure to teach and support claims for a patent. And the scope of rights under TRIPS, the right to exclude others from making, using, selling, offering for sale, or importing your invention. Okay, Article 27, I've already mentioned 27.1, but I haven't mentioned Article 27.2. And here are some quite interesting measures which reflect the fact when you look at this text, you'll see that this borrows a lot of language from the European Patent Convention. So whereas you might say that the copyright part of TRIPS is pretty much reflects United States wishes, the patents part is a sort of compromise where between United States and Europe, And the compromise works this way because Europe is, in these respects, very different from the US. United States, there are no statutory exceptions to patents. There are non-statutory exceptions, right? I mean, there are exceptions on natural products, exceptions on natural phenomena, laws of nature, and also abstract ideas. But European patent law has a whole list of inventions that are not patentable, including inventions that are immoral or contrary to ordre public, to use a French term, as well as things like plant varieties. European patent law also has exceptions for things that are not inventions. For example, discoveries are not inventions. So the US and Europe are quite different in terms of subject matter. As a consequence, you have this was compromise language. So it may exclude diagnostic, therapeutic, and surgical methods, the treatment of humans or animals. May exclude inventions that are seen as being immoral. May exclude plants and animals. So you can say that plants are not patentable, animals are not patentable, but you have to allow microorganisms to be patentable, where they are inventions. And then the other language, again, reflects the European practice, which is to exclude plant varieties from patent law because there is a separate IP system for patent law. So TRIPS offers the same possibility. You do not have to. You do not have to provide patent protection for plant varieties or animal varieties, but you must at least provide an alternative system of protection for plant varieties. Animal varieties, there's no need. In fact, there's not that much IP going on in terms of breeding animal varieties anyway. So many developing countries particularly have opted for an alternative, effective Sweetener system just for plant varieties rather than using patents. In the same way, in Europe, we generally take the view that classical plant breeding should be kept outside of the patent system because plant breeders prefer to have an IP system with very, very broad exemptions. And patent law doesn't generally provide those sorts of broad exemptions. Okay, trademarks. Well, here's a definition of trademarks. Basically, you may well know this anyway, but trademarks are signs that are capable of distinguishing goods or services from one business from those of another. Signs can consist of words or phrases, images, visual images, including abstract ones. They can also nowadays include shapes, combinations of shapes with colors, and sometimes even smells. But they must be acceptable to, well, visually, although, as I say, olfactory, from the nose sense. We have some of those as well, but not so common, to be honest. So so figurative marks, word marks, colors, and shapes. So for example, let's take a recent medicine, Viagra. There's trademark on the word mark, Viagra. Of course, the generic name is sildenafil, which no one is allowed to have trademarks on. There's also in some countries trademark on the color, the blue color of the pill, and also its shape as well. So trademark has become quite expansive, and TRIPS rather encourages this expansive protection, not just words and abstract visual signs, logos, etc., but beyond that as well. And therefore, there's the scope of protection, the right to prevent all third parties without consent from using in trade identical or similar signs, which result in a likelihood of confusion. Of course, this goes to the heart of justifying trademarks. Trademarks, where they perform their function, are useful for owners because where there is goodwill in the trademark, it attracts customers to your goods, and also it attracts customers who want to come back again for repeat purchases or consumption. From the perspective of the consumer, it makes it more efficient for them so that they can search for their products. And note that trademarks are particularly important in crowded markets where there are lots of substitutes. So trademarks, let's say in wine or in beer, there are lots of different kinds of beer, lots of different kinds of wine, or cheese, coffees, etc. And an effective mark will enables the consumer in supermarket with thousands of different types of brand overall to find the product that they actually want to choose, because they trust that product, they like that product for whatever reason. Okay, I won't get into this, but there's also a certain, let's say, privileges or additional protection for marks that are well known, famous marks. So I'll leave you to read that one, okay, for when at your own time. I'd like to move on to geographical indications. Here are a few. These are European ones. Here are two cheeses: barrel-aged feta, which comes, of course, from Greece. Here you have the protected designation of origin, which is on the European system here. Another one here, and this is a protected geographical indication, which is European system. Is quite interesting. All right, I'll come back to that a bit later. Now, as I already said, the geographical indication is quite a new concept. It's not just new in trade law, but it's new in intellectual property more generally. Although it does derive in part from appellations of origin, which goes back really to France and the wine trade in the 19th century. So it does have some historical antecedents. So here's the language of TRIPS. There's no real clear definition of a geographical indication in the legal sense at all. So it says here, indications which identify a good as originating in the territory of a member, or a region or locality in that territory, where a given quality, reputation, or other characteristic of the good is essentially attributable to its geographical origin. So what is an indication? It's likely to be a place name, but not necessarily. Obviously, an obvious example is Champagne, which comes from the Champagne region of France. So it's given quality, reputation, other characteristic is essentially attributable to its origin. So can we have Californian champagne? Well, what is champagne? Champagne is a sparkling wine. If we think champagne champagne is just a sparkling wine, then it seems perfectly reasonable for a sparkling wine that is very similar in taste to any champagne produced in the Champagne region in France can be called champagne. If it's Californian champagne, at least there's no deception as to where it comes from. It's a sparkling wine that was produced in California, but it is evocative of or similar to, or even the same as, champagne comes from Champagne. But if champagne is a geographical indication, then it becomes arguably a fraud on the public, where sparkling wine in California is called Californian champagne. Okay, they're not deceived into thinking it's from Champagne, but the fact it's called champagne is a fraud on the public in the sense that they're expecting it to be exactly the same, to embody the same, what the French call terroir, the specific characteristics of a particular space, a particular place on the world. Using the same skills, the same material, and it won't be the case. It won't be exactly the same. And so if you think one takes the view that that champagne producers in Champagne have acquired goodwill on the basis of a high quality alcoholic beverage, then, and you say that this product is very specific to that region, then it would be not just unfair on the public, but would actually be wrong. It would be a kind of free riding for producers somewhere else in the world to call it champagne. On the other hand, our geographical indications are protected, where it is perhaps harder to make the case that only in this place could this product be made. And that is perhaps a reason why, or one reason why geographical indications are so controversial. But there is a bigger reason why United States, Canada, Australia, New Zealand, more could go on, actually Latin America, Argentina, why these countries generally are quite critical of geographical indications. These countries were historically colonized by Europeans. In some cases, they were colonists or neo-colonial relationships with European countries, where they provided the role of producing goods for the European market. And then they became more independent, and then they became trading nations in their own right. And of course, what did Europeans do when they emigrated to the New World? Was that they took with them their place names, they took with them their plants, their lifestyles, their occupations. And so these countries tend to think that geographical indications purely suits the interests of European agricultural producers, who, of course, as with textiles, cannot possibly compete on a basis of scale, of volume. They can only compete on a basis of quality or the perception of quality, which is rooted in history and the growth in reputation that they have acquired and fame. So you have an almost philosophical conflict between different countries, based not just on economic interests, but based on cultural and national identity, and the sense of national pride and of independence, and of having acquired the status of being countries which have their own separate interests from Europe and don't feel they owe any kind of debt to the Europeans anymore. And that's why geographic indications are so controversial. But another thing about geographic indications is that TRIPS, in some ways, is very unclear as to how a geographic indication, a GI, should be protected, how to do it. Because actually, members of the World Trade Organization are not required to provide a legal system of protection. Not exactly. And I'm not given any indication of how to actually do it. How do you protect a geographic indication? They must, the absolute minimum, provide legal means for foreigners to prevent use of a geographic indication in your jurisdiction. In other words, the United States must, at minimum, provide a legal means for the champagne producers to go through US courts or go through a regulatory body in the United States to stop the use of champagne on products that are produced outside of the Champagne region of France, for example, in California. The problem is, how far does this go? One can accept a strong case for champagne because it has acquired this reputation over a very, very long period of time. But what about something which doesn't have that fame, where there hasn't been as much investment in goodwill? Because there are lots of geographic indications in Europe where the case for an obligation of the United States to provide legal means to protect them is much, much weaker. There are products which are granted geographic indication status in Europe where, you know, and I should add, the EU does not have a strict examination system, right, that evaluates objectively the specificity of any particular product that is protected. And this, I would say, is a big problem. I don't usually express my strong opinions to students, but I'll just say that the European system, it actually does go too far. I think there are good grounds for protecting geographic indications, but they really must be genuinely specific to a local place. As long as that's done, then you can come with a compromise between the US and Europe. But without that, you won't get a compromise. So just to say here that the EU doesn't provide, I'm talking about the TRIPS rather. TRIPS doesn't provide any particular legal system. I mean, patents are very clear, inventions, copyright is very clear, trademarks, but geographic indications, how you protect a GI, the TRIPS agreement has almost nothing to actually say. So here are a few ways you can do it. United States says it can all be done by trademarks. You know, if you can't protect it by trademark, then you shouldn't be allowed to protect it. And obviously the Europeans have a very different position about this. Okay. I should add here that trademarks and geographic indications are quite closely related to unfair competition. Unfair competition is actually mentioned here. So, is use of indication champagne a case of unfair competition? If it's used as unauthorized and for products that are not made in Champagne, the region of France, is it unfair competition? Well, it's arguable, isn't it? Okay. Okay, so those are the IP rights I'm going to talk about for now. This is something I've already talked about basically in relation to TRIPS. Just one thing to add is that Article 6 is quite relevant, not just to patents, but it is relevant to IP generally, but exhaustion of rights shall not be a matter for a trade dispute. In other words, if a country engages in parallel importation and makes that legal, then there's nothing any country can actually do about it through the dispute settlement system. All right. Okay. Just wanted to add that. Okay. Ongoing controversies about geographic indications. I won't go through all of this because I think you there's plenty here for you to read, which follows up what I've been saying. It isn't, you know what's controversial, and that's so I said so, and this is adds further detail about that. Oh yes, I want to say also about undisclosed information. It is very, very important. It didn't seem very important at the time. Now, Article 39 of TRIPS, undisclosed information, Article 39.1 is about what we generally call trade secrets. What is a trade secret? A trade secret is a secret. It is a secret. It has commercial value, and reasonable efforts have been made to protect that secret. It is not an absolute right. A trade secret is not an absolute right. If you're able, through what you call reverse engineering or studying a product, you're able to find out the secret, it can be done legally. And then there's nothing that can be done to, the owner of the secret can't do anything to stop this. So let's take a good example, right? The recipe for a Coca-Cola drink. It is a trade secret. There is a recipe, and the recipe is in a safe in a bank in Atlanta, United States. If you found out the secret by breaking into the bank, blowing up the safe or blowing the safe open and taking the secret, well, you'd be guilty of a few crimes there, but among other crimes, you would be you'd be guilty because it is a trade secret and you haven't used illegal means to find the secret. On the other hand, if after years of analysis of the product, you are able to figure out the secret to how to make Coca-Cola and make it exactly the same as the company's product, that is not illegal. That's perfectly legal. Okay, I'll say no more about trade secrets, except to say that they are very important in a lot of businesses. And it's often said that technology transfer to developing countries can be helped if there is strong protection of trade secrets. That's the view I've heard. But I want to move on to Article 39.3, which is to do with experimental and test data that must be undertaken for the regulatory authorities, the government, to approve the marketing of a medicine or an agricultural chemical. Now, medicines and agricultural chemicals are products which are highly regulated. Obviously, you can't just make up your own medicine and sell it. It has to be approved, and it has to be approved on the basis that it is safe for the patients who will receive the medicine, and it is effective in those patients. To produce data to prove that both are true requires clinical trials, laboratory testing, and those trials take time and are extremely expensive. Now, the patent owner of a medicine has 20 years, because the patent term is 20 years. It's not very long as with copyright, or indefinite, possibly permanent in the case of trademarks. It is a 20-year right. Well, for much of that 20 years, you may actually, a company may be undertaking these tests And if they're undertaking tests as a condition for approval, they're obviously not making money. They spend lots of money, they take on risk, they're not actually making any money. So from the perspective of industry, well, this is a big expense that we're undertaking, and we don't even know if our product is going to be approved. So therefore, we would like to have some rights in relation to how that data that we provide to the drug regulators is used by the regulators in terms of approving generic products. Because once the patent has expired, the market is open for generic producers to introduce their competing product. Now, generic producers don't have to undergo the same costs. All they need to do is to prove that their copy is equivalent to the original medicine in terms, in two ways, in terms of its chemistry, but also in terms of its effect when taken by a human being. That is much less expensive and takes much less time. And of course, a drug regulator, will compare the data provided by the originator drug company and compare with the data provided by the generic firm. And of course, that comparison also takes much less time to examine, because we have already examined the thousands and thousands of pages of clinical trial data and laboratory data. So the industry managed to get this language put into the agreement. Members shall protect such data against disclosure, except when necessary to protect the public, or unless steps are taken to ensure the data are protected against unfair commercial use. Protection against unfair commercial use. How do you protect against unfair commercial use? Is any of that unfair? It's not really clear. It would be unfair, obviously, if a generic company that want to enter the market were just given all of the test data, say, here you are, and you can use it as you wish. That probably would be unfair commercial use. But note that the generic company doesn't really need access to that data. What it just needs is enough samples of the original drug that it can be used for its own testing and comparison with its own products. And then it is the regulator that actually uses the data provided by both for the purpose of comparison. So what this means in terms of law is extremely vague. However, the United States has turned this into an exclusive right. So there must be 5 years delay before a regulator is allowed to compare the data. In Europe, it goes up to 11 years data exclusivity. And Europe and the United States have both been promoting this interpretation of TRIPS. And why is that important? Because it has the potential to delay generic entry even beyond the lifetime of the patent on the drug. So it is really quite controversial. The TRIPS agreement and public health. So that gets me onto this subject. There are a number of important things to point out here, but again, I don't think I want to spend forever on the TRIPS agreement. But if just a few more minutes to say that Article 30 provides a 3-step test, very similar to the copyright 3-step test which we've already seen and discussed. And the 3-step test here is unusual because it really belongs in copyright, but it has been shifted into patent law. Patent law has tends to have 2 main exceptions. One exception is for experimental use, experimental, private and experimental use, and the other is for non-commercial use, experimental and non-commercial use. But this is different language. This is quite a different language, and the question is, what does it actually mean? And of course, you have to have a dispute in order to really understand what it means. Canada received a complaint through the WTO from the European Community, the European Union, about its law, which allowed a generic company to make the invention, in order to do the experimental work to produce a generic version to enter the market after the patent expired. So essentially, the generic company is infringing the patent during the lifetime of the patent, but for the purpose not of selling the drug, but of getting marketing approval from the regulators. The law went a little bit further and said, the law in Canada said that it is also legal for the generic company to stockpile its medicine. In other words, to put it in the blister packs and put it in boxes, printed boxes, ready to go out, to be stored and ready to go out to the public as soon as the market authorization has come through and go and sell it. Well, the European Union objected to this, said it was in violation of Article 30. So a panel was established, including a chap called Mihaly Fixer, who is a well-known copyright expert. It takes a copyright lawyer to understand what this means, even though it's a patent dispute. And the panel report, which came out, I think, about 1999, essentially said that Article 30 does allow a regulatory review exception. It allows a generic drug company to make the drug if only for the purpose of seeking marketing authorization. But stockpiling of the medicine, so producing it for sale and preparing it for sale so it is in its packaging, it fails the three-step test, and therefore that is not allowed. So Canada had to change its law to continue. It was allowed to continue with the regulatory review exception, but it had to cancel the stockpiling exception. Interestingly enough, after that dispute, the European Union, now knowing the regulatory review exception is legal, adopted it into EU law now. And actually, a lot of countries have now done that, but I say not the stockpiling exception. And then there is the issue of compulsory licensing, which is permitted under TRIPS. Compulsory licensing has become actually a particularly interesting issue this week in relation to COVID-19, because a number of countries said that they are going to provide compulsory licensing in order to prevent one company from having a monopoly on any treatment, any drug or vaccine to deal with COVID-19. There are rules under TRIPS about this, and due to the AIDS crisis in the late 1990s, there was pressure for the members, for the World Trade Organization and its members to take into account the importance of compulsory licensing in order to provide AIDS drugs, but at the same time to accommodate the problem that many developing countries do not have the capacity to manufacture AIDS drugs in their own market. And of course, compulsory licensing must be for the manufacture of medicine in your own country. But if no one in your own country can make it, they can't take advantage of compulsory licensing. And so in 2001, there was a declaration on TRIPS and public health, which acknowledged this problem and declared that there would be that the members would try to find a solution to this problem. And that did actually lead to an agreement in 2005 to amend the TRIPS agreement to facilitate the process of compulsory licensing. Of course, if it's going to be manufactured in another country, 2 licenses have to be given. A license to be given in the manufacturing country, and a license to be given in the for the importer country. 2 licenses, but this time 1 payment to the patent owner. Of course, this only applies in countries where there are patents on the same medicine in both countries. If there are no patents, then you have freedom to do what you like. The system that was adopted through this amendment to TRIPS, we have to admit, hasn't been particularly successful. It's only really been tried once, and it wasn't a particularly happy experience from the perspective of the generic drug company, which is a company in Canada called Apotex, which provided it to Rwanda in Central Africa, because Apotex was not able to make money out of this. Of course, they have to make money too, and this was a loss for them. So the amendment to TRIPS is not really very reflective of the business model of industry. So it does require a bit of a rethink, one might say, and perhaps it's time with the COVID-19 pandemic now to do a big rethink. So that's a thought for us all today. All right. Okay, I think I'm going to leave TRIPS there, but leave you with this slide. Why is TRIPS so controversial? And then we're going to go on to agriculture. Oops, agriculture. Here we are. So I'll stop there, and here's where we will continue. Let me just turn off. Sorry, you can switch off now while I figure out.